2023. I think you deserve a round of applause for that. We also have the Governor of Nairobi County, His Excellency Johnson Sakaja. We are also going to be joined later on today by the Secretary to the Cabinet, a good friend to many of us, and that is the Honorable Fellow Certified Secretary, Mercy Wanjao. We are also anticipating the entire bench of the Supreme Court of Kenya, our apex court, which have just managed to become distinguished fellows of the Chartered Institute of Arbitrators. We will be referring to them as CIArb Supreme Court Justices. In addition to that, we will be having the Attorney General's Emeritus of Kenya, and that is Honorable Senator Amos Wako, as well as Professor Gidu Mwigai, Senior Counsel, who will also be with us in this conference. That is the Kenyan contingent. Allow me to also recognize the presence in this room of our global president of CIArb International, none other than Jonathan Wood, Chartered Arbitrator. He's the guy who is also wearing some serious hardware like me. We are also privileged to have with us the Africa Trustee, CIArb Global, Dr. Chikwendu Madumere, also present in the room with us. In this room also, we have the chairpersons, my fellow chairpersons of CIArb from the following countries: Zambia. Where are you, James? I saw. Oh, there's a new president. Okay, there's an emeritus president and a new chairperson. Yes, so there she is, Miss Simba Nyakasamba. Please welcome from Zambia, from Rwanda. She's here somewhere. From Nigeria. From Pakistan, and from Egypt. The chair of Pakistan actually, please stand up so we can also see you, chair of Pakistan. Or he's coming in later on today, but he spoke to me. I know he's personally going to be here present. And also from Egypt. Yes? And hopefully very soon to become chairperson of a branch, but chairperson of our baby, the charter. Where are they? Uganda, yes? David Kagwa? There they are. They are also there and they're present with us. So each of the chairpersons have come with members from the different CIArb branches in and around Africa, and we do appreciate your presence here. We have the again, Court of Appeal judges. We have also the High Court judges. Allow me to also recognize the Honorable Mr. Justice Richard Mwongo, Judge. Yes, as well as leaders of different arbitral institutions and professional bodies. We're expecting the President of the Law Society of Kenya, the President of the Kenya National Chamber of Commerce and Industry, and Kenya Institute of Supplies and Management. Distinguished ladies and gentlemen, it is my honor, it is my privilege to welcome you to the celebrations of 40 years of CIArb Kenya. And we celebrate this day at a time, yes, oh my dear, sorry. We have attorney generals from the Republic of Malawi, Honorable Attorney General from the Republic of Malawi. There he is, there he is. One of the reasons why I took my time to let everybody know who is in the room with us, distinguished members of the Institute. I know many of us are CIArb, we're CIArb, but we are all either fellows or chartered arbitrators and aspiring fellows. So I want to encourage you to continue with your journey right to the apex qualification of CIArb Kenya. We are big in training and we continue to contribute to knowledge management in this country. We are in research, we are in development, we are innovating. And other than that, and one of the reasons I also say that is because there is a rumor out there that in Africa we do not have the expertise to be international arbitrators. It is a lie. It is what? It is a lie. And we are the people, once life begins at 40, so we are the people who are going to prove that lie and demonstrate that it is absolutely not true. Yes? Yeah, so I'm very excited. I'm also very nervous. And I'm in a celebratory mood. And I want to celebrate just one or two things before I call upon our chief guest to give us their keynote addresses. And one of them is this. And I was talking about it just now. It has just, I'm sure it's become public knowledge that the Honorable Attorney General has taken the national ADR policy to Parliament. I'm sorry, ADR community, are we really excited about that development? If I had the power, I would have asked you to give him a standing ovation. It is a historical accomplishment. Thank you. You may be seated. Honorable Attorney General, the chairman of the National Steering Committee, who led the development of the national ADR policy, is in the room today. He's none other than the Honorable Senior Counsel, John Ohaga, and I believe that we ought to recognize him for this brilliant accomplishment. So many of us have stood on the shoulders of giants, even as we celebrate the 40 years and as we contemplate where we are going. And it would be remiss of me if I did not also recognize the person who actually got me to step into leadership and the path to growing CIArb, my namesake and the first lady chairperson of the Institute, the Honorable Lady Justice Kamau, Jacqueline Kamau, who is here with us today. In 40 years, many things have happened. When CIArb was established in 1984, we had the Arbitration Act, 1968. And we had a group, not of lawyers, but of quantity surveyors, engineers, and architects who came together to consider dispute resolution. So I also want to recognize the presence of everybody in the built environment industry for forming this institute, for taking the initial steps of leadership in this institute, and also allowing us lawyers to come in and do what we do best, which is take over. So please, can we acknowledge the built environment for the good work that they did and that they continue to do. Yes, it's good that they brought in the lawyers because in 1995 we got our first Arbitration Act, which was midwifed by the then Attorney General. We know him because he's the one who also midwifed the promulgation of our Constitution. Our fellow Senior Counsel, the Honorable Emeritus Attorney General, Amos Wako. We are hoping that he will be joining us as we move along. And in that season, It would also be remiss of me not to mention that in the promulgation of the Constitution, specifically of Article 159, 2C and 2D, there was a conversation that happened, and Honorable Richard Mwongo tells that story so well, and I'm sure he's going to repeat it, of the chair then of the CIArb, that is the Honorable late Justice Johnny Havelock, and the then Minister for Justice and Constitutional Affairs, Mutula Kilonzo, and we found our way very grounded fundamentally into the Constitution of Kenya. So those are some of the highlights of what we've been able to achieve in the many years that we have been around, and we don't want to continue to stay in one place and jog in one place. So the last thing that I will say is that we are looking forward to continuing our partnership. We have a very good partnership with the judiciary. We also have a very good relationship with your office, and we are hoping that we will continue to further the discussions in this particular space. In my excitement, I've realized that time has really moved on, so we will continue to engage, we will have discussions, intellectual discussions, we will talk to the future, we will talk about research and publications, we'll talk about how we will develop arbitration and ADR in general in Kenya. But for now, allow me to welcome you to our conference, dubbed CIArb at 40. Thank you very much.
Thank you very much, Madam Chair, for those wonderful remarks. Honorable Attorney General, there is a joke that is running in the streets about that the government does not joke with time. And I think we witnessed an interesting episode where people who were late for a cabinet meeting were locked out. The Attorney General is rushing for a cabinet meeting, and the worst thing that we could ever do is to have him locked out of the cabinet meeting. I don't know whether CIArb would be sufficient reason for his admission. So allow me to change the program slightly. We will hear a few short remarks from the Honorable Justice Musinga on behalf of the CJ of the Republic of Kenya, and then we will go straight to hear the opening and keynote address by the Honorable Attorney General. Before we break for our photo shoot, we will come back then and listen to remarks from our global president and also remarks from our Africa trustee. So we want to make sure that you're on time. And the first thing he told us when he arrived, by 9:15, I have to be at the State House. So please, ladies and gentlemen, without much further ado, may we welcome the Honorable Presiding President of the Court of Appeal to make remarks on behalf of the Chief Justice of the Republic of Kenya. A round of applause. Karibu sana.
Thank you very much. I cannot add anything more than what is written here because I'm delivering my boss's remarks. But I only want to say she's apologetic. She sends her apology that she is unable to be here today, but she'll be here tomorrow. She's held up in a very important engagement. The President of the Chartered Institute of Arbitrators, esteemed members of the Chartered Institute of Arbitrators, distinguished guests, ladies and gentlemen, good morning. Good morning. It is with great pleasure that I address you today on this momentous occasion, the 40th anniversary of the Chartered Institute of Arbitrators, Kenya branch. On behalf of the Kenyan judiciary, I extend my heartfelt congratulations and best wishes to the CIArb Kenya on this remarkable milestone. As the Chief Justice of Kenya and patron of CIArb Kenya, I am acutely aware of the significant role that arbitration plays in our legal landscape. It is undoubtedly a preferred mode of dispute resolution that not only alleviates the burden on our courts, but also provides parties with a more efficient, cost-effective, and flexible means of resolving disputes. Before I go into the core of my speech, allow me to celebrate the Supreme Court fellows who have made immense contributions to the field of arbitration and ADR in Kenya. Their tireless efforts and unwavering dedication have paved the way for the growth and development of alternative dispute resolution mechanisms in our country. The judiciary is working diligently to promote the use of various alternative dispute resolution mechanisms in our nation with the aim of enhancing the administration of justice. However, today, I would like to focus on a few important aspects. Firstly, the judiciary is putting in the unwavering dedication to ensure that the principles of natural justice and due process are upheld in all arbitration proceedings to safeguard the right to procedural fairness. As we all know, upholding these principles not only foster trust and confidence in the arbitration process, but also uphold the integrity and legitimacy of the entire system. As the patron of CIArb, one of the initiatives I am deeply committed to is the concept of multi-door approach to dispute resolution, which aims to provide parties with a range of alternative dispute resolution options, including mediation, arbitration, and conciliation. This multi-door approach not only relieves the burden on the court system, but also enhances access to justice by offering tailored solutions that address the unique needs of each case. Through this innovative approach, we can ensure that dispute resolution mechanisms are accessible, efficient, and cost-effective for all members of society, regardless of their socioeconomic status. By promoting the use of ADR, we can empower parties to resolve their conflicts in a more collaborative and harmonious manner, fostering a culture of peaceful coexistence and conflict resolution. I firmly believe that the multi-door approach to justice model aligns seamlessly with our commitment to upholding the principles of justice, fairness, and the rule of law. It offers a comprehensive framework that encompasses a wide range of ADR methods, ensuring that the most appropriate mechanism is employed to address the unique circumstances of each case. Additionally, the judiciary intends to work with the CIArb to address and remove any barriers that may hinder access to arbitration to ensure that justice is accessible to all, regardless of their socio-economic status. Furthermore, it will actively promote the benefits of arbitration through judicial pronouncements, public awareness campaigns, and collaborations with various stakeholders. This includes highlighting its efficiency, cost effectiveness, confidentiality, and the finality of awards. I am committed to partnering with the Institute to safeguard the integrity of ADR processes including arbitration, by ensuring that proper regulatory frameworks and the ethical guidelines are in place to maintain the credibility and effectiveness of these mechanisms. To uphold the twin objectives of arbitration, we will pursue the goal of streamlining dispute resolution procedures to ensure that they strike a balance between efficiency and fairness. This includes encouraging the adoption of modern technology, promoting the use of emergency arbitrators, and supporting initiatives that foster timely and equitable resolution of disputes. As a patron of CIArb Kenya, I am committed to fostering mentorship and training opportunities to ensure continuous professional learning and leveraging my position and network to explore various options that can benefit the Institute. We will work closely with the Institute's leadership to understand their vision and goals and lend my support in any way possible to ensure the success of their affairs. To conclude, the judiciary affirms its unwavering commitment to the principles of justice, fairness, and the rule of law. Together, we can build a stronger and more efficient legal system that serves the needs of our nation and its people. Let us embrace the power of arbitration and ADR and work towards a future where justice is swift, fair, and accessible to all. Thank you and God bless.
Thank you very, very much. I did not have your bio, Honorable Presiding Judge of the Court of Appeal, but I can say one thing about what you've done from the tender years at the university. You have made arbitration very, very popular with our students at the university and our young members group. And I think you really deserve a round of applause for the investment you've made. Thank you. Honorable Attorney General, your bio is very lengthy, but I will say one thing. For those of you who would like to make reference to it, it's on page 4. We remember you very fondly because of words that were associated with your persona, and that was order, order, order. The Attorney General, of course, has an illustrious career as a Speaker of our National Assembly. Most of us will remember him trying to contain the politicians and make sure that they walked the straight and narrow. But today, he is speaking as a champion of the ADR policy that he has spearheaded himself. And he's also speaking as the line ministry that is responsible for matters related to ADR. And ladies and gentlemen, without any delay, please put your hands together. Let us welcome the Honorable Attorney General of the Republic of Kenya. Karibuni sana. You are most welcome, sir.
Thank you. Please be seated. Well, I think the Vice Chair almost took me back to my previous assignment. I was going to, until I saw former distinguished Senator for Busia, the Attorney General Emeritus Shitswila Amos Wako in the room. I was going to say, Vice Chair, that now there's order in the house. The Honorable Tabo Chakaka Nyirenda, the Attorney General of the Republic of Malawi, the Honorable Justice Daniel Musinga, President of the Court of Appeal, Mr. Jonathan Wood, the Global President of the Chartered Institute of Arbitrators, other distinguished members of the Institute, the Chair, ladies and gentlemen. I take this opportunity on behalf of the government and the people of the Republic of Kenya to extend a warm welcome to you all to Nairobi. I am delighted to be in the midst of such an esteemed gathering at this 8th International Arbitration Conference, and I say, Karibuni. I want to congratulate the Chartered Institute of Arbitrators Kenya branch for organizing this 8th International Arbitration Conference, which I'm informed coincides, as indeed has been said, with the branch's 40 years of existence, and therefore I say to the branch, happy 40th anniversary. I note that this conference aims to bring together users, practitioners, policymakers, government agencies, and academics to map out the future of alternative dispute resolution, particularly in the continent of Africa. Ladies and gentlemen, you will no doubt be aware that the public sector, or indeed the state, is the foremost user of cross-border and investment dispute settlement. Speaking on behalf of my jurisdiction, Kenya, we have a long-standing commitment to the rule of law, and this extends to the amicable settlement of disputes through the various international instruments to which Kenya is a signatory. From the onset of the Republic, Kenya signed the International Convention on Settlement of Investment Disputes on 24th of May 1966, and has submitted the jurisdiction of arbitral tribunals appointed under the convention in which the state is a party. Our record as a state party speaks for itself with an impressive success performance. In addition, Kenya ratified the Convention on the Enforcement of Foreign Arbitral Awards, the New York Convention, on the 10th of February 1989, demonstrating a commitment to honor enforcement of foreign citizen awards. In 1995, Kenya enacted the model law on arbitration, and the chairperson has already made reference to it, the Arbitration Act of that year, which is the legal landscape, which has shaped the legal landscape by a robust jurisprudence which underscores judicial affirmation of the limited role of court intervention and support for the arbitral processes. Indeed, our Constitution embraces alternative dispute resolution as one of the principles guiding the courts and tribunals in the exercise of judicial authority. To support the legal infrastructure, the government of Kenya, through the judiciary, has facilitated key interventions such as the establishment of the Commercial Division of the High Court, increase in specialties capacity of judges who are qualified in arbitration, mediation practices, and ongoing training of judges and other judicial officers. We've just been told by the chairperson about the recent qualification or accession by the full Supreme Court bench. And I dare say, and to this, as I was saying earlier on, that I was pleasantly surprised when I discovered that one of my classmates, Justice Friend Ochieng, leads the section on court annexed mediation process in the judiciary. As a principal legal advisor to the government of Kenya, my office appreciates the pivotal role that dispute settlement through arbitration plays in our globalized and interconnected world. It serves as a powerful tool to resolve disputes efficiently, confidentially, and impartially, while promoting international trade investments. On my part, my office has presented to the National Assembly and indeed the chairperson has already made this reference. The Alternative Dispute Resolution Policy being session paper number 4 of 2024 that will shape the organized progressive growth of the dispute resolution space into a transformative agent for social change and sustainable commercial relationships. And I wish to thank, at this point, the members of the task force who worked so tirelessly to come up with the policy. And indeed, reading through it made it very easy for me to push it through Cabinet for authorization to transmit to the National Assembly. What is following closely are 3 legislative proposals. 1, the Dispute Resolution Bill. 2, the Construction Payments and Adjudication Bill. And 3, an amendment to the Arbitration Act Bill of 1995. I want to urge the Institute and its membership to support these interventions that will modernize our legal infrastructure for dispute resolution. Ladies and gentlemen, we are making significant strides in strengthening our legal framework to create an even more arbitration-friendly environment. Our Arbitration Act reflects international best practices and principles, providing a robust foundation for arbitration proceedings. But nevertheless, due to the other developments, there is need to have it rejigged. As we continue to improve on our arbitration and ADR infrastructure, we remain committed to upholding the rule of law and ensuring access to justice for all. As you convene here today, let me remind you that the success of arbitration lies in our ability to ensure the independence, integrity, and transparency of the process. More needs to be done by all in the ecosystem of arbitration to ensure that reforms aimed at making arbitration responsive to the needs of the modern era are realized. Global arbitration practice must not only be viewed as a tool for settlement of disputes, but also a guarantor of equal access to an impartial adjudication irrespective of the economic differentiation of parties. Moreover, globalization has made cross-border transactions and disputes a common reality. In this interconnected world, arbitration has emerged as an essential tool to resolve international conflicts. Embracing diversity and recognizing the impact of different legal systems, cultures, and customs is vital in making arbitration a truly global and inclusive mechanism. Ladies and gentlemen, let us also acknowledge the role of sustainable development in the arbitration sphere. Climate change and environmental challenges are no longer abstract concepts, but tangible realities affecting nations and communities worldwide. Arbitration must adapt to address disputes arising from environmental concerns and corporate social responsibility for a more sustainable future. Another crucial aspect you must explore is the role of arbitration in promoting gender equality and global regional diversity. By fostering an inclusive environment and encouraging equity and equal representation in arbitration panels and leadership roles, we can ensure fairer and more balanced outcomes. Lastly, the world we live in is rapidly evolving, driven by technological advancements, geopolitical shifts, and changing economic dynamics. As arbitration practitioners and enthusiasts, you must acknowledge that the status quo is no longer enough. To remain relevant and effective, you must proactively embrace change and meet the challenges of the future. The digital era has revolutionized the way we conduct business, communicate, and resolve disputes. Online platforms have disrupted traditional business models, creating new challenges and opportunities in arbitration. In response, you must harness technology's potential to streamline arbitration procedures, increase efficiency, and enhance access to justice. However, with technological advancements come concerns about data privacy, cybersecurity, and potential bias in algorithms. As guardians of justice, you must tread carefully to strike the right balance between efficiency and fairness. The future of arbitration rests on your ability to master technology while preserving the integrity and values of the arbitration system. Ladies and gentlemen, on this 40th anniversary, I applaud the Institute's Kenya's branch for the important role in nurturing the arbitration practice in Kenya and the Africa region. The Institute's commitment to train and accredit arbitrators, mediators, and adjudicators has ensured a steady supply of capable professionals for the dispute resolution fraternity. I also note that the rich range of topics for discussion bring together the best minds in arbitration. I believe this conference will provide a unique opportunity to engage in knowledge exchange, foster collaboration, and be a healthy critic of modern-day challenges faced in arbitration. It is the exchange of diverse perspectives that fosters growth and innovation in any profession. In this regard, I trust this 3-day conference will spark insightful discussions and trigger changes that will improve the arbitration practice. It is my hope that you have a chance to enjoy the hospitality of Nairobi and the Kenyan people. Ladies and gentlemen, with these remarks, I wish to formally declare the 8th International Arbitration Conference open and once again celebrate the Institute's 40th anniversary. Thank you very much. Congratulations. And ladies and gentlemen, before I leave, because it was explained by the chairperson and the vice chair as trying to elaborate, is to just excuse myself, because we have a very unique situation in which cabinet meetings start with a word of prayer led by none other than the president himself. So ladies and gentlemen, I have 5 minutes to make my way into State House, but I wish you fruitful deliberations. Thank you very much. God bless you.
Honorable Attorney General, we have a gift for you just before you leave. Ladies and gentlemen, while you're upstanding, the Honorable AG can come to the front. I will invite also the Global President to come to the front, the Africa Trustee, and the Chair. This is a gift that we were to give to you, Honorable AG, tomorrow in the awards presentation. The Chair will just say 1 or 2 remarks as she gives you the gift. It will be presented by our Global President. We are acknowledging the role that you have played in leadership in the ADR policy. Inside there is an elephant, symbolic of so much that you've done. And we're also giving you one on behalf of the President of the Republic of Kenya, His Excellency, Dr. William Samoei Ruto, because certainly he has been the principal pushing the program. So as you go to the cabinet meeting, do pass our regards and that elephant that is very, very symbolic. Ladies and gentlemen, let us give them the honor that they deserve. We will then ask a few of our groups. There's a quick photo shoot as he walks out. We'll ask the board, the global president, the Africa trustee, several chairs that are present, emeritus, including our very own Senator Muswako. As the Attorney General leaves, there is a photo shoot. For the rest of us, please, there will be some tea that will be served. We will resume here at 10 o'clock sharp. Please, those who want to know where the photo shoot is, that is a gentleman to follow. But Tom, maybe you can raise your hand. Oh, okay, all right there. All right, again, I thank you so much for opening the ceremony. Makofi kubwa sana. We adjourn until 10 o'clock. Thank you very much. Justice Mwongo, the photo shoot is actually out there. We can together, yes.
to share the platform of the distinguished achievements in shaping the landscape of ADR in the region and beyond the borders. In this regard, I extend my invitation on behalf of the CIArb ADR, on behalf of the chairperson, the directors, members of the honorable judges, judicial officers, to all the dignitaries, and to everyone in attendance, in person and online. Karibuni sana, welcome. May I take this opportunity to introduce our first keynote speakers. The first, it's our pleasure and a great honor to invite the president, the global president of the Chartered Institute of Arbitration, Mr. Jonathan Wood, Chartered Arbitrator, CIArb. May I request you, please, Mr. Wood, to... Where is he? He's on his way. Okay. Right, while we're waiting for the president, I can tell you a brief introduction of this conference this morning, and I can see, yes, Mr. Jonathan Wood has arrived. In your absence, I did invite you. Yes. Okay. Thank you very much once again. May I request the African trustee, Dr. Chikwendu Madumere, to please welcome the global president, Mr. Jonathan Wood. If you may take then a few minutes to come and invite the president of the Chartered Institute of Arbitrators. I think you're representative of the global trustees, so if you could just a few words for introduction. Thank you.
Good morning, everyone. Please allow me to stand on protocols already established by Madam Chair early this morning. It is my singular honor and privilege to welcome our global president, Mr. Jonathan Wood, to come and give us his keynote address. Thank you very much, sir. Please come on stage.
I just want to take a moment. First of all, Jambo. But I want to take a moment to look round this room and say what a heartfelt pleasure it is for me to realize that I am your president and I'm in the company not just of important but very special people. It is a great honor to be here. Chikwendu, when I was voted in as president, like all good athletes, he was the first out of the blocks. And before I knew where I was, the ticket to come here was in my inbox. And it was the first invitation I received, and it is the one that I hold dear to my heart. So to celebrate your 40th anniversary, and I've got several years beyond that, let me just tell you, it is a supreme honor, and I'm most grateful. So let me be serious now. I have 3 daughters, now well grown up and advanced in their careers. 2 of them are teachers. One of them is in charge of decolonializing the curriculum vitae in their school. The other one is a geography teacher. She constantly reminds me, Africa is a continent, not just a country. When they were teenagers, I gave them a book, the autobiography of Dame Margaret Anstey. Born in 1926, Margaret Anstey had a stellar career as a British diplomat, perhaps best noted as being the first female staff member to reach the rank of Under-Secretary General of the United Nations in 1987. Margaret Anstey was born near where I live in the village of Writtle in Essex in the UK. Her father was a printer, her mother in domestic service, leaving school at 14 and 12, respectively. They were deeply determined to have only one child and ensure it had the best education they could manage. The village schoolmistress held the conviction that country children were not as intelligent as their town counterparts, and those who had the misfortune to be female were less so. In defiance of the school authorities, she got to Newnham College in Cambridge. She studied languages and got a first. She joined the British Foreign Office in 1948 and was assigned to the South American desk. It was Foreign Office policy in those days never to send a woman diplomat to Latin America, for fear, and I quote, she would succumb to the wiles of some passionate Latino. She joined the UN serving in Colombia, Uruguay, Argentina, Bolivia, Ethiopia, Morocco, and Chile. She was involved in peacekeeping missions and economic development, utilizing skills many of us deploy in our practices. She was an exceptionally competent woman with a dry wit and sense of humor. She passed away in 2016. The title of her autobiography was Never Learn to Type. You can just imagine in those days her response to a male colleague who had been in the same meeting as her saying, "Margaret, could you possibly type up the minutes of this meeting?" I don't type. Marvelous. What a way of dealing with the position of a woman in those days. Why tell this story? Well, it's a tale of social mobility achieved through education. And we at the Chartered Institute are essentially concerned with education. As I say, she was an extremely competent woman. I am often asked what people should look for in an arbitrator. My shorthand response is a competent neutral. Neutral is well defined. You can find a definition in the model law, in the institutional rules, in the case law, but not so competence. And when I say competence, I do not mean competence, I mean competence. How do we acquire competence? More importantly, how do we assess competence? The starting point is surely education. There is remarkable growth in tertiary education at universities in the study of international arbitration. Far more so when I started, when you just learnt on the job. I learnt my skill as an advocate at the expense of the poor hapless victims of the English criminal court system. That was the way it was. You only have to witness the capability of the students taking part in the Vismoot to recognize the importance of the universities in providing a grounding in international arbitration. When I attended the Vismoot in Vienna earlier this year, in March, I was delighted to see that a record number of those taking part came from Africa, and I hope that that will continue to grow as the years go on, They did a fantastic job in attending the Vismoot. Then there is self-learning. As a result of the pandemic, technology has supercharged the opportunity of self-learning. My inbox, and probably yours too, is full of invitations to webinars, seminars, and conferences. The internet is replete with learned articles on every aspect of international arbitration. But neither a degree nor self-learning really tells anybody about the competence of an individual as an arbitrator. And that is, of course, where the Chartered Institute of Arbitrators steps in. As you know, the Chartered Institute was founded in 1915. We now have 19,000 members and 44 branches. The last one was opened in Saudi Arabia some couple of months ago, and I had the privilege of attending in Riyadh to sign the memorandum which gave rise to our new branch there. And again, another privilege. We launched the Education Committee in 1927. And in the last couple of years, work has been underway to develop a competence framework. There are pathways to achieve a level of membership graded by post-nominal designation, member, fellow, chartered. So the user knows the level of competence of a particular arbitrator, not just from the point of view of knowledge of the law and the process, but practical aspects such as award writing too. And that applies wherever you go in the world, whether it be here in Kenya, in Nigeria, in Latin America, North America, or Europe. The designation is universal. Our institute promotes itself as a diverse and inclusive organization from all points of view: gender, religion, social background, ethnicity. And perhaps significantly, there is the comfort that all membership levels are underpinned by a regulatory framework. Every year, when you renew your membership, you have to sign an undertaking to abide by the CIArb Code of Professional and Ethical Conduct for members. So there is an objective measure of competence supported by a degree of regulatory oversight. You wouldn't go to an architect, you wouldn't go to a doctor without checking on their credentials. So why should it be any different for an arbitrator? So let me return to the tale of Margaret Anstey and her exhortation of never learning to type. With the advancement of technology, things like speech recognition, even typing may be a competency that has now been taken out of my hands and possibly yours. Margaret rose through the ranks as a result of education and experience. In 1922, the CIArb Journal pronounced study and experience alone constitute the equipment of an arbitrator. A designated post-nominal demonstrates a level of competence and ability. The point is this: it gives confidence in an arbitrator, it gives confidence in the process, and it gives confidence in arbitration as a whole as a globally recognized way of resolving disputes between international parties, which is essential for investment and prosperity. Thank you very much.
When you started speaking about AI, we had a very animated discussion yesterday at the Young Members Group, and I was hoping, Mr. President, that you would have veered into that area and its impact on arbitration going forward. But we're very, very thankful and honored to have you. And when we say the global president, I think it's in order for us just to recognize chairs that have come from very, very long distances. I know we have the chair from Pakistan. If we could ask them to stand up. There we are. And Egypt. I think Egypt is also present. There we are. I think let's give them a real African nakaribishwa. You are very, very warmly welcome. We want to transition, and thank you again, Jonathan, for being so prudent with time. We would like to transition to our first panel, and they are present. I will introduce the moderator. I have been searching for her. I'm not 40, so my eyes could be playing tricks on me. Kananu Mutea, for some reason. Yeah.